Good morning, ladies and gentlemen. Thank you for joining us on this beautiful Friday morning. We welcome you all to this legal writing masterclass. Justices that are on call, professors, advocates, and colleagues in law, I'm so happy that we join this call today to discuss something that is very important to our profession as lawyers. The Uganda Law Society and the Muslim Arbitration and Mediation Center Uganda are proud to bring this vision to life. My name is Zubeida Namgenyi, and I'm the CEO of the Muslim Arbitration and Mediation Center Uganda and the editor-in-chief of the Legal 14 newsletter, a platform that encourages lawyers to write and to tell their stories from the legal lens, and to basically discuss how we can promote advocacy in our space. In our legal landscape today, the declining quality of legal writing is impossible to ignore. Conflicting judgments confuse the public. Judges lament the poor quality of pleadings and submissions by advocates, and advocates struggle to express arguments with precision. And ultimately, it is our clients, the very people seeking justice, and the people we seek to represent, who suffer the most. Every careless word, every unclear sentence, every poorly drafted submission delays justice and sows confusion and erodes trust in our legal system. How many legal brilliant minds have been let down by weak writing? How many cases have been lost, not because the law failed, but because the words failed? This is a crisis that has to be dealt with. To help us tackle this challenge, we are honored to have speakers who I am very, very proud to introduce. Justice Benjamin Odoki, CJ Emeritus, who is joining us from his home. I would like Justice Odoki, if you're on the call, please just say hello so that we're clear that you're here.
Please come. He's waiting for you. Who's waiting?
Okay, we are now locked on your line.
Why? Stop.
You are most welcome, Your Lordship.
Good morning.
Good morning, Your Lordship.
Yes. How are you today?
We are great. We are happy to have you.
Yes.
Yes, I would like for you to take a minute to say hello to the participants before I go on and introduce the other speakers.
Okay. Good morning, learned friends, and all those who are watching us and listening, senior members of the bar and members of the Radical Bar, and
Yes.
otherwise, and then the judicial officers present on this program. Good morning once again. My apologies. My apologies for logging in late. We had a few technical problems, but now I hope you can hear me.
Yes, we can hear you loud and clear.
Oh, that's good.
Okay. Thank you, Your Lordship. His Lordship Benjamin Odoki is a towering member of the legal practice, and he was born on 23rd March 1943 in Busia District, Eastern Uganda, and stands as a towering figure in Uganda's legal history. He was educated at the King's College Budo and his LLB at the University of Dar es Salaam, followed by a postgraduate diploma in legal practice from the Law Development Center. He began his public service as a state attorney in 1970 when he quickly
Recording in progress.
He quickly transitioned into the judiciary, and by age 35, he had earned an appointment to the High Court. He rose from where he rose to the Supreme Court. He chaired the Uganda Constitutional Commission from 1989 to 1993, steering the drafting of the 1995 Constitution, a milestone and document that is very instrumental in our nation's democracy. He has served in several other capacities as Director of Law Development Center, Director of Public Prosecutions, Chairman, Judicial Service Commission, and in 2001, he became the 10th Chief Justice of Uganda, serving until 2013, and he also served as an acting Justice of the Supreme Court thereafter. He wrote many decisions, like Fulgencio Mungereza versus PricewaterhouseCoopers Africa, which upheld the need for courts not to interfere with arbitration. Attorney General and Susan Chigula, that removed the mandatory death sentence. He was also part of the quorum in Koyelo, a constitutional appeal. His judicial roles in Uganda have also been complemented with his international roles, such as being a member of the Permanent Court of Arbitration in The Hague, the Administrative Tribunal of the African Development Bank, and as a judge of Eswatini Supreme Court. He is an author, an academic, and a reformer. He chaired the editorial board of the Uganda Law Reports, taught at Makerere University, and wrote extensively about criminal justice, human rights, and constitutional law. His notable works include The Search for a National Constitution and the making of the 1995 Constitution. He has been honored both at home and abroad. His awards include Uganda Independence Medal, Distinguished Jurist Awards, and from both the Uganda Law Society and the Nigerian Association of Democratic Lawyers, and the Gussie Prize, Peace Prize International Award in 2012. We now move to the next speaker, Dr. Anthony Kakoza. Dr. Anthony Kakoza is an advocate of the High Court, and he has practiced law for over 22 years. He is a partner at Biencha, Chihika, and Company Advocates in charge of intellectual property in the Intellectual Property Department. He is an accredited arbitrator and a mediator of intellectual property disputes with the World Intellectual Property Organization, WIPO, and he has worked with WIPO on projects related to the regulation of traditional knowledge and folklore in Uganda, Malawi, and Ghana. He was formerly the Dean of Law at Uganda Christian University, and currently he is an adjunct visiting professor at the University of Illinois, USA. Doctor, please say hello to the participants before we move on to introduce Mr. Muchibi.
Good morning, our dear participants. Now it's on? Okay, good morning to our dear participants. I'm very happy to be here and looking forward to the various interactions that we're going to have. Thank you.
Next is Mr. Paul Muchibi, who is the head of Department of Law Reporting, Research and Law Reform at the Law Development Center. He is an external examiner at the School of Law, Makerere University, Kampala. He has lectured in many universities, Uganda Christian Universities, School of Law Makerere University, the Law Development Center, and the Uganda Management Institute. He is a senior partner at Muchibi and Cheyune Advocates. He also holds numerous professional journals and editorial board memberships, such as the Insolvency Journal of Uganda, URSB editorial board. He holds a master's in higher education, management and administration. He holds another master's in international trade, policy and law from Uganda Matters University in Kozi. He holds another master's in business administration from the Uganda Management Institute and an LLM from Makerere University, Kampala. Mr. Muchibi, the man of 4 master's degrees. Please say hello to the participants before we proceed.
Thank you, Madam Zubeda, for that humble introduction. Good morning, our viewers, members of the bar, members of the bench, academia, and public following us now. You are welcome to this session, and I believe by the end of the session, your writing skills will have drastically changed, and we shall indeed have impactful drafting. Thank you.
Thank you very much to our distinguished speakers. Your wisdom today will sharpen our minds, refine our craft, and inspire us to write with clarity, precision, and conviction. This masterclass is a call to arms, and I hope that by the end of it, we can do better. But before we move forward, I wish to express our deepest gratitude to our partners, Uganda Technology and Management University, UTAMU, Honorable Justice Mike Chibita, Justice of the Supreme Court, Mr. Philip Odoki of the Uganda Law Reform Commission for standing firmly with us. Colleagues, let's seize this moment and let us write better and let us utilize our speakers. Ask questions, engage meaningfully, and let's make the most of this session. I would like to invite the most perpendicular Vice President of the Radical New Bar to make his remarks before we dive right into the masterclass. Thank you.
All right. Thank you, Zubeda. My Lord, Chief Justice Emeritus, Justice Benjamin Odoki, members of the bench who are following us, our distinguished speakers, members of the bar, ladies and gentlemen, good morning to you all. I do bring you greetings from the President and the Council, the Governing Council of the Radical New Bar, who are not able to be here with us physically today. For me, it is my distinct honor and pleasure to welcome you all to this continuing legal education training, amply titled the Legal Writing Masterclass. Legal writing is a craft that needs to be refined and plays a critical role in upholding justice, advancing legal thought, and shaping the rule of law in our society. In fact, I do applaud Zubeda and team for coming up with this particular topic, because it is one area that has been ignored by many, yet the most important area in the field of practice, legal practice, and access to justice in this country. We are particularly privileged to begin this training with a keynote address by none other than Chief Justice Emeritus Benjamin Odoki, a jurist whose judgments have left an indelible mark on our jurisprudence. His address, titled Writing Judgments That Shape Jurisprudence, promises to provide deep insight into the art and responsibility of judicial writing, reminding us that words, when wielded with wisdom and clarity, can influence generations of legal interpretation. You heard Zubeda introduce Chief Justice Emeritus, and for sure, his works speak for themselves. You don't need to explain a lot. In fact, personally, I'm excited to hear from Emeritus, Chief Justice Emeritus. Beyond the keynote, this masterclass brings together a panel of esteemed speakers who will guide us through the practical pillars of legal writing. Specifically, we would delve into drafting court documents with precision, where clarity and structure are not just stylistic preferences, but legal necessities. I used to work in a jurisdiction where sometimes I'd look at pleadings, even before I look at the address, I know who has drafted. The same as judicial officers. And I've always told people, especially the students I do teach, that for you to succeed, to handle a matter in court, it begins from the drafting. From there you draft your work. It's the most important aspect of your work. So I believe through this particular area, we're going to, to appreciate and learn more about drafting court documents, the do's and the don'ts. We shall also have the nuanced worlds of copyright, trademarks, and transactional writing, where precision in language translates into protection of rights and commercial certainty. And I have no doubt that a doctor here, my namesake, has a wealth of experience and knowledge to share with us in that field. Each session, as elaborated above, is designed to be not just informative, but transformative. Whether you are a seasoned advocate, a judicial officer, or a legal scholar, let us approach today with open minds, a willingness to sharpen our pens, and perhaps even reimagine how we write law, interpret the law, and ultimately serve justice through the written word. Once again, I welcome all of you to the Legal Writing Masterclass, and I thank you for your commitment to professional growth and to excellence in legal writing. Thank you very much, and I wish you the best of the day. Thank you.
Thank you very much, Mr. Vice President. And I would like to invite His Lordship, Justice Benjamin Odoki, to give his keynote. Thank you.
Good morning. Good morning once again.
Good morning, Your Lordship.
I'll meet all the protocols, but I say the Vice President and members of the learned profession who are present. First of all, I want to thank the executive of the Law Society for inviting me to participate in this workshop. I've taken long without teaching, and therefore you will forgive me if I don't meet your expectations. I did not know what you meant by a master class or writing class or whatever, but you asked me to talk about judges, not lawyers. I believe some of you will soon be judges. And I would encourage you to aspire to serve the country in all dimensions of the legal profession. The first part of my talk would address a bit of theoretical aspects of writing, and At the end of towards the end, I'll deal with the technique or the crafting of judgments in a briefly. All of you know what a judgment is, and you remember Lord Macmillan defined judgment as follows. A judgment may be defined as a reasoned pronouncement by a judge on a disputed legal question which has been argued before him or her. It is a literary composition, but a composition subject to certain prescriptions and conventions. It possesses its own characteristics and its own standard form. The art of composing judgment is not taught. It is acquired by practice and by study of models provided by numerous volumes of law reports in which are recorded the achievements of past masters of the art. In this quotation, you should note the following important points. 1, it is a reasoned pronouncement on a disputed legal question. 2, it is a literary composition with its own characteristics and study form. 3, the art of composing judgment is not taught but acquired by practice and study of good models in law reports by masters of the art. You should remember for whom judgments are written and addressed. They are addressed to the parties, they are addressed to the lawyers, they are addressed to other judges, and they are addressed to the community or society at large. You should also keep in mind the roles of the appellate courts. As you know, appellate courts perform a specific role in a given legal system. First, to correct mistakes of the lower courts. 2, to clarify the law where it is vague, ambiguous, or in conflict with other laws or precedents. 3, to promote the rule of law. 4, to protect human rights. 5, to promote democracy, constitutionalism, good governance, accountability and transparency. 6, to advance socio-economic and political development. 7, to develop the law to keep abreast ever-changing socio-economic conditions. Bear in mind, if you are on appeal, that those objectives need to be kept in mind. What are the traits or shortcomings in writing judgments? Some time ago, I quoted the Justice Trainer, who also quoted the Wigmore. Wigmore is the authority on evidence about shortcomings, because you need to know these shortcomings in order to address them and move forward. What are they? Lack of acquaintance with legal science and with the system of legal knowledge, which includes legal philosophy, jurisprudence, social discrimination, and best sources of knowledge. This lack of knowledge may be due to lack of proper education, or lack of time, or indifference. 2, unfamiliarity with the body of controlling precedents. Many judgments sound as if the author have discovered the basic principles for the first time. No. Overemphasis on the technique of legal rules with corresponding emphasis on policies, reasons, and principles. 4, undue servitude to the bondage of precedent. I did this letter. Undue servitude to the bondage of precedent. The failure to recognize which courts and which cases merit the status of binding precedent. 5, over consideration of every point of law raised in the proceedings. This leads to unnecessarily long judgments. 6, a one-man opinion of appellate courts rather than judgment being intellectual distillation of all. 7, corruption and political bias. 8, economic class bias. To what extent are these threats true in Ugandan appellate courts for you to interrogate? There are also a few talented and gifted judges who clearly and sanctifully state the facts and outline the issues arising from them, and then apply the law to such decisions. They believe the function is to decide the case, not to collect the cases or expand on the legal philosophy or principles which may be relevant. There are those who are guilty not only of over-consideration over the point of law raised in the proceedings, but who exhaust all possible avenues in great detail. They delight in technicalities, fine distinctions, and exotic developments of possible themes. One is said to wonder whether exhaustive opinions of this sort are written more for personal gratification or scholarly exercise rather than resolution of legal issues. But these opinions may be justified to some extent in appellate courts. Yes, another professor identified some other mistakes in judgment writing. One, including things that needed to be recorded. 2, deciding things which don't need to be decided. 3, obscuring the analysis with the poor organization and irrelevant details. 4, neglecting the aesthetic component of persuasion. 5, making the analysis more complex than it really is. Everything that is unrelated to the issues should be cut out. Every word must earn its right to be on the page. That's economy of words. Now, what are the skills which a judge requires? Judges should possess or cultivate the following skills or qualities to succeed in writing authoritative judgments. 1, critical thinking, analytical mind. 2, teamwork and collaboration, including collegiality. We know we're talking about appellate courts. 3, professionalism and a strong work ethic. 4, oral and written communication skills. 5, leadership and managerial skills if you are the leader of a court or a leader of a panel. Time management, research expertise, presentation competence, courage in decision making. Don't be a timorous soul. As Lord Denning said. Decisiveness and firmness, hard work, energy, and stamina. ICT, computer skills. Those of us who are born before computer suffering, with this. But now you people, you are even doing artificial intelligence. We shall see how you can write judgments with that. All these skills are overlapping and are mutually interconnected and reinforcing. They form an integrated whole to produce the required competence for judgment writing. Critical thinking, the thought process, very important. You must have disciplined process of analyzing, evaluating, and applying information to guide actions and beliefs. It involves skills such as open-mindedness, problem solving, inference, explanation, evaluation, self-regulation. They need to have adequate knowledge of the subject matter, e.g., in the relevant area of law. You may specialize, you may not specialize, but you must have adequate knowledge of the subject in that judgment you are dealing with. When I served in Swaziland for the last 10 years, I had to learn Roman Dutch law, which is different from the common law. And if you're on the appellate court, you have to know that you are criticizing judges and the lower courts who know much better than you. So I have to learn very fast to understand things like delicti. They have the civil law system and Roman law system, Roman Dutch law, and the structure interdict, which are really more known in that area than in the common law. It requires a bit to sort out relevant and irrelevant materials and use to their effect. You need to apply the values of and principles of accommodation. We're talking about appellate courts. Accommodation, alternatives, pros and cons, consequences, and balancing conflicting and competing interests. When you have constitutional law, human rights, and so on, you have to address all those matters. You must identify the problem, research the problem, determine the relevance of information required, and ask relevant questions to identify solutions and present solutions. You must have ability to study and analyze large mass of documents. You will have about 20 volumes, 100 volumes in the election petition or whatever, or even constitutional cases. You must have ability to study and analyze large mass of documents contained on the record of proceedings so that internalize what is the major issue or problem identified in the case to be addressed. In my experience, I know that found that there's only one issue which decides the case. Once you knock it on the head, you have knocked the nail on the head. One issue, and that will solve all cases. The rest will just be following. But you must be able to internalize the case so that you can write that judgment. In appellate courts, you work as a team, and teamwork is needed it involves cooperation, communication, shared understanding of the task ahead, and shared responsibility. In political science, they call it collective responsibility, but for us, we call it shared responsibility. Teamwork is intended to improve productivity, better problem solving, two heads are better than one, fosters a sense of comradeship and mutual support. Appellate judges work in panels and therefore in teams. Each member of the judge plays a critical role in advancing the common goal in dispensing justice. I believe you heard of collegiality, which is very important between colleagues. They need to have cooperation and interaction. The group takes the collective responsibility to work together with minimum supervision. It improves staff morale and organization efficiency, while fostering a culture of trust and shared learning. Now that is about conduct. Maybe we don't need to know about comradeship of judges, but it affects writing, as we shall see later. But of course, there's also disadvantages, because judges want to retain their independence. They can be a bit not very cooperative, and sometimes if you are very competent in a particular subject, you are given, you are normally asked to write, or you may be asked to help write that judgment. So you might have disproportionate work, but otherwise, that is how it is. You have a shared responsibility, and you work together as a team. You need the communication skills. Writing is about communication, and you need communication skills, presentation competence. You need legal reasoning and the judicial style. Every judge has his own judicial style. I don't know how many of you have read my judgment, so they can know it's judgment written by emeritus. But I note that my judgments are not the same as judgments of other judges. So they used to say that I was writing for students, but I never wrote for students. No, I didn't. But I was conscious that you need to go through a structured system of writing a judgment so that it's understood and is enforceable, is effective, and so on, and advances the goals which I've set out earlier. So you need a good command of English language and vocabulary for effective communication. Most of us who studied law had studied literature and were good at English. So you need clarity of thought, consensus, and brevity are essential. Conciseness and brevity are essential. Use of quotations on the authorities where they are necessary. You can shorten them or paraphrase the content. Limit the use of italics except for emphasis. Minimize the use of Latini. you like to add but mutandis, and so on, and the prima facie. Some of those cannot be replaced. Prima facie, for instance, is quite difficult. But things like for locus in core, you can go to the scene of crime and so on. Anyway, minimize the use of Latin because some of the people were reading that the judgments never studied Latin. Use gender-sensitive language when you are writing the Constitution. We are faced with the issue of he includes she, and the lady said, no. They may.
Recording in progress.
Humor is not necessary in judgments. Because litigation is serious business. You're not there to abuse anyone. Obiter dicta, many people want to write, before I leave this case, I want to do the following. Don't make obiter dicta less necessary. We're not hearing information unless the matter has a reason in the proceedings and the serious matter which you need to raise concern, then is when you can write obiter dicta. Although not part of the judgment, but I think it raises concern. Brevity is one of the qualities which I would encourage. A judgment which is 300 pages is not, unless it's a very big case. And I think that the shorter the judgment, the better, even if it is on appeal. Because remember to whom you're writing the judgment. Unless it is a case of first impression, you can just bang the decision as short as possible. Yes, you need research expertise, research the judges who write good judgments, do research. They don't depend very much on lawyers alone. As the record is produced, they research the issue. Maybe they already have some precedents which they have collected. So you need also to deal with the research, the developments in the law in other jurisdictions and so on, which are similar to Uganda, and identify those which can be applied to Uganda. So a comparative study is good. I remember I've quoted some cases from outside in Uganda, even in other jurisdictions. Cases, I have also quoted cases from Uganda. So a comparative analysis is also useful, and it's reinforcing. Today, judges are privileged to have research assistants. You will see that all the judgments I wrote a long time ago, we never had research assistants until recently. The current judgments are better quality. Even in ADB, we never had research assistants. You are consultants, you write judgments. In Eswatini, there are no research assistants. You write judgment yourself. You research and write judgment. But Uganda is, I think, I don't want to say it's advanced, I think it has followed the American trend of having law clerks to assist in research and writing legal opinions. So research is important. You need to continue updating your knowledge. Don't depend so much on what is on record and lawyers and so on. Individual development is very important. And that's how you'll be able to write judgments which distinguish you from anybody else. I'll keep a few things because now I know there are skills which are required for leaders in the courts in the appellate courts because of the panels. And the rest people need leadership skills. They need to know how to handle their colleagues and so on. I've not had any problem myself with leading people, senior judges, maybe because they're mature. But you have to respect them because they have the ideas are almost, you have to respect their opinions and give them the necessary latitude because independence, judicial independence is individual, but an appellate court is collective. Together, you project the independence of the court. So it is a shared responsibility. That's where you have to be able to. But nevertheless, my style, I used to encourage video judgments to write, people to write their own judgments to reflect the depth of their knowledge and the experience so that other people can learn. So the issues of time management, many judges can't write judgments because of stress. They agonize so much. And later on I'll tell you about judges who never start writing and those who never never finish writing. So management of stress is important. Goal setting, you must be able to say, I'm writing this judgment, I will finish it in 2 weeks' time or one day. So time management is important. You must avoid.
Recording in progress.
And agree how the judgment should be, and also decide who should write the judgment. Sometimes people offer, sometimes the head may ask one judge to, depending on the workload, to write. In some jurisdictions where I worked, judgments are already, those who are to write judgments are allocated in advance. In the African Development Bank Administrative Tribunal, judges are allocated cases in advance before the trial. In Eswatini, cases are allocated to judges in advance. I mean, those who write judgments, they will know that you are the right, you are the one to write judgment. And all the judges prepare knowing that I have 5 judgments to write, and I must write them and deliver them. So there are those areas of where the leader determines, or the registrar determines by random, depending on the workload, and there are areas where judges offer. I think the structure of judgments. Now, there is no hard and fast rule about structure, but you must have a structure, outline of how you write your judgments. Most judgments, the judges start with an opening paragraph, starting the nature of the case, identifying the parties. This is an appeal against so and so. An appeal, second appeal, first appeal, on this ground brought by so and so, in this court, blah, blah. Second, the question to be decided. 3, a statement of the essential facts. 5, a discussion of the law applicable. and disapplication to the facts found, and the disposition of the case. That's a general outline. But then there are subdivisions of the grounds of appeal, the arguments of counsel, all those you integrate them into an outline. So then the analysis sometimes is, if you have said my judgments, I prefer the opening statement, and I go to the background of the case because I like people to know the story. What's the story of this case? Before I go to the grounds of appeal, before I go to the submissions of counsel, before I go to the consideration of the grounds, and ground by ground by ground by ground by ground. But you can also have grounds considered in an analytical manner. Ground one, submissions and finding. Others want all the submissions to be in one section, then the consideration of the grounds in one section. I don't have any first and hard rule about any of those things. So long as you are able to analyze each ground separately and come to a conclusion, which is easily discernible for students who are interested then die on a particular issue, even that, both for the appellant and the respondent. So their research is equally important. What I've said applies to lawyers as well. They need to research, they need to know contemporary issues and so on, and they need to know also why are they preparing the cases and to serve what purpose, societal purposes. So that is very important, and they should not underestimate their role in guiding courts. The role of president, when you are considering the law applicable or applying the law to facts, you must remember we have a common law system which is based on the precedent that previous cases can decide the future cases. So general rule that precedents must be respected. And you remember what we put in Article 132? Is it 132 or thereabout? That previous decisions of courts of the Supreme Court are binding, and the court is free to depart on previous cases where it is right to do so. That's the doctrine of precedent. It was explained a long time ago, I think by the House of Lords. So we tried to codify it in the Constitution. And also it was also codified in the East African Court of Appeal. So you may depart from precedent, but before you depart from precedent, you must be able to understand the precedent itself and analyze it and see whether it still fits socioeconomic conditions. You may clarify the precedent, you may depart from it. You may create new precedents. You remember we created some, I don't know whether we created it, I don't like saying that the judges will make law. I think we can say they expand the law. They interpret and expand the law, but in that process, of course, you can say they make the law. So you will see that in the case of Makula, which made the death sentence discretionary. That was really changing precedents and making new law. The death sentence became discretionary. There was a case of NRM rebels where the court said that leaving a party means you must leave voluntarily. You cannot be, if you're expelled, it's not, you should say, we have expelled you, but if you have said, whoever leaves a party, we must also leave members of parliament. We said, no, you can't leave members of parliament because party did not elect you. That was the case of the so-called rebel MPs. Also, there was a case of, I don't think we made the law, but I think we made a policy decision that IGG doesn't have power to punish people. The case leadership code, you must go to the leadership code tribunal. And we said the leadership code must be established so that they can. You cannot be a investigator, prosecutor, and a judge. So we said there should be a leadership tribunal. I think that was like a policy. Judges can be policy makers. I think some of the people have argued so. There are many other cases which I don't want to go into. Judges always ask you, do you have a recent case on this matter? As if all the cases are dead. So lawyers appearing before judges, even judges themselves, they try to look for the latest cases on a subject, because it might give some more insight into the development of the law. And I want to say that it's not how many cases you decide it's not how many cases you decide, but what is the quality, what is the relevancy, and so on. I think in some jurisdiction we said you should quote 3 cases on a particular topic, not more. And then the issue of written and oral submissions. I prefer a hybrid of both, I mean a mixture of both, that were used in Uganda here before, I think recently, to oral submissions. And oral submissions are very important. They sharpen the mind of the lawyer, counsel appearing. When the judges ask them questions, they become very, very clever. They learn how the mind of judges work. But when you have written your submissions, the judge is sandbagging on a computer. You don't know how the judge thinks. But the moment you are submitting the judge, you know the mind of the judge, where he's going, whether he's progressive, whether it's conservative, whether it's radical, and you interrogate each other. And so I think that oral and written submissions should be encouraged, not just written submissions, go and write submissions. Well, in your time, when you appear before a judge, after hearing the case, he will say, can you make your submissions? Not tomorrow. You will make submissions there, and tomorrow the judge will give you a judgment. Whenever I used to take his judgment, so judgments many are not known. We gave a date, and you get the judgment during that time. Yes. So we are for quality of judgment, quality of submissions, not quantity. They will produce quality judgments. Yeah, lawyers also need to, as well as judges, understand principles of interpretation of statutes and of constitution, because that is very important in development of the law. And that's how the law is expanded. That's how the law grows through interpretation, not only of cases, but also of statutes. So they must be familiar with the principles of interpretation in terms of human rights, in terms of constitutional law, in terms of even contract, civil law systems, civil law, and so on, divorce, and so on. All this, how do you interpret statutes? How do you interrogate, and so on. So that's how the law is going to be developed. Jurisprudence is very important in a growing country like Uganda, and so I think the lawyers played a very important role in assisting the courts in developing the law, and the more learned they are, the better. I think that that responsibility is shared by both the teaching institutions as well as the law society itself, which is program of continuing legal education. So I think that this is a good program for lawyers. As you know, I was a lawyer teacher at one time. Maybe you have forgotten when I set up the bar course 1972. I think some of you were still growing up, but we set up that course, and we provided not only for legal training, but also for continuing legal education by the law, by both LDs and the Uganda Law Society. So I think this is a very important program. I came here because I value training, because although some of us are now outdated, we still have some knowledge to pass, and I'm glad that you recognize that. And I'm sorry I've taken too much of your time, but and I do hope that I'll have more opportunity to interact with you by the grace of God. Thank you very much, and I wish you good deliberations.
Thank you so much. Thank you so much, Your Lordship. We have learned so much, and my greatest takeaway is that every word should earn its place on the page. Members, if you have any questions.
She really listened. No, this is
Are there members who have questions? Please type in the chat. Would you like to ask? Please go ahead.
Thank you so much, Councillor Zubeda. Thank you, CJ Emeritus, for that good and elaborated guide. I understand the judiciary is developing a JWT, judgment writing tool. In the Tech Fest we had a few weeks ago, we were informed by one of the panelists from the bench that it will be rolled out very soon, perhaps next year. Your Lordship, I would want to know whether you've been one of those consulted and give some of those insights to it. You talked about the obiter dicta and when it is needed in the judgment, how should it be done? Secondly, you also talked about something I see lacking in most of the judgments today, critical analysis. In most cases, what we are seeing is adopting submissions of counsel, which are written, as you've mentioned, and the analysis sometimes is not coming out properly. Then that judicial speech, you see the judge coming out to give a clear and an unambiguous decision. We have seen judgments and the issue is resolved, but you are all not getting the decision. What is the decision on this issue? It is just hanging. It is here, it is there. So there is no clarity. And lastly, which I didn't hear in the presentation, which I think is also that I've seen so many judgments where judges don't give final orders. They resolve each issue, and when you sit down to extract a decree, you get problems extracting a decree. You go issue by issue, you don't find a conclusive decision. At the end of the judgment, the final orders are not also there. What will be your take on those issues? Thank you.
Yes, I say the dicta should be given only in cases where it deserves. This is where the judges express some outrage or advice to the government, to either the lawyers or the parties or the government, to express the dissatisfaction with a particular approach to things. Like if lawyers don't prepare and say, before I take this matter, I want to express our concern that lawyers are no longer preparing this and this and that. Or the government is not doing this, or and so on and so on. So obter dicta is something which, like, advise, express something concern, raise the concerns of the judiciary on a certain matter to the parties, so that it can be rectified. But it comes out of the judgment, but not necessarily part of the judgment. I've also had, connected to that one, people who, these days, there's a tendency to give directives to government. They must be relevant to the case and they must be enforceable. We know, I can advise, I have practiced law, studied. There's a principle that you cannot give a party a remedy he has not applied for. So you cannot, in a Roman Dutch law, you cannot give an order in a matter which is not in the suit. So you cannot volunteer to give orders outside what the parties have claimed or answered. That's the same principle as or before I take this, or now we advise this, you may not be able to enforce some of those things. So it has to be careful when you're giving orders or giving or expressing your opinion or directives. Yes, and I think we've got to correct this critical analysis. This idea of adopting submissions of you don't adopt submission. The judge should be able himself to write what his analysis of from all what he has seen. Not also, okay, if somebody said so, you can say yes, he said so, but I disagree. And the council submitted like this, I don't agree with that one. But not just to adopt submissions and so on and so on. If you agree with the council, you say so, that it was submitted to us like this, but sometimes not necessarily even to talk about submissions. As a judge, you're supposed to, if you read all the cases in East African law reports, submissions are not there. And not that law has never appeared, but the judge himself is analyzing the case without necessarily, the lawyers have spoken, now it's for the judge to speak. So adopting submissions and so on is very, I don't want to say anything, but if you read my judgments, I don't adopt any submission. I have to analyze the case myself. It's not your submission. My view of what you have said, or my view of the law. And that's why the law is made. When I make a statement about the law, it's original. It's not, you can quote it. It's not what somebody has. So, so I agree with you that that is a weakness. Lack of critical analysis of, not just capitulating what somebody has said and so on. Clear and ambiguous decision. I should have emphasized this. In our decisions, you must say this appeal is allowed or dismissed with the following orders. You must give orders of the court, even an ADB or a Swatini. You say decision of the court. This case, either the appeal is dismissed or we make the appeal. There are plenty of winners or the appellant, and that is the decision of the court. And then we make the following orders. Even costs, even if you're ordering a retrial, you're ordering anything, you must make the order at the end. So decision is different from the order, because the decision is okay, the outcome of the case, and of course the consequential orders are consequential. Yes. I think those are the
Your Lordship, about the judgment writing tool.
Oh, you asking me whether I've been consulted?
Yes, that was his question.
I have not been consulted. I have not been consulted, yes. But I don't deny anybody. I think we have got some judges who have worked outside Uganda and we can have a comparative. Maybe they have got people who are consultants from other countries. I would be happy to look at the tool. But the tool mainly is used for formatting. It's for formatting the cases. And in some countries, like where I was in African World Bank, where it was an international tribunal, with judges from all the jurisdictions in Islamic, Roman Dutch law, common law, civil law. The formatting was done by the secretariat. Once a judge writes a judgment and is discussed and approved, then there's a format which the ADB has approved. It will follow the same format. It will be reduced in the form, whether you have written it in a different way, but it will have your words. But the formatting will be, they will change things according to how it's supposed to go, the narrative. So I suppose it is useful. But it's not something which is like a specimen where you just fill in. It is, and it does not affect mainly the substance. It's the format. And so that all the judgments are the same, whether you are numbering or you're not numbering, whether you are headings or not headings, they will be the same. And whether you are underlining, whether you have italics, whether quotations are written, the format will include in how you write quotations, how you write the paragraphs, and so on, and how you enter the judgment. Yes, thank you.
Thank you very much, Your Lordship. I'll go to the comments, to the chat section. Cynthia H. Musoke says, thank you very much, CJ Emeritus. Mwesigwa Apollo asks, what is his take on abolishing LDC? And Bitature Vicent says, thank you very much, Your Lordship. What do you recommend in respect of online submissions and judgments? Your Lordship.
LDC.
Yes, abolition of LDC.
Now, you people, I'm sorry. Maybe I'm a bit getting a little bit out of that. I don't want to call you young people, but I want to say that in 1995, I wrote a report on legal education, training, and accreditation. In that report, I recommended demonopolization of LDC. 1995, that's how many years ago?
More than 20.
Well, what have you been waiting for? 1995, after writing the Constitution, I wrote a report, World Bank report. On that report, on that committee, I was with Professor Juko, Justice Bosa. I was the chairperson, lead consultant, and Professor Asante from Ghana. We wrote that report. It's there. Report on legal education, training, and accreditation. We recommended demonopolization of LDC. And yet I was among the original veterans of LDC. But I knew it could not cope. The back course, we're running the back course alone because of the numbers. So have you gotten the point? I suggest you read my report.
We will, Your Lordship.
Yes, you'll be wiser.
Thank you, Your Lordship. The other question was about online submissions and online judgments?
If you are going to the you are digifying whatever your system, because we introduced computerization in the courts. We had hoped to have online filing, and in other countries that's what has happened in Kenya and Zambia and so on. I think we got some programs from there to insist in online, but we are late in having online filing. So there's nothing wrong with online filing. What you're talking about is online judgments and submissions. No, all these things, you have to be able to balance. You have to be to balance societal conditions, because if you are submitting judgments online, a person in my village there, how would he get the judgment online? Because giving it to the lawyer. Are you talking about appellate courts? Maybe appellate courts only, where people are represented, but there could be litigants in person. We used to get a person there in the Supreme Court when I was in Mengo. He used to be in the Mengo in the Supreme Court when I was in the Supreme Court before I became Chief Justice. There was a litigant there who was always appearing in the Supreme Court. In the person, I think he's dead. So that person, submission line, yes. There's nothing wrong with submissions, making submissions online. But what I'm talking about is that there must be a window to allow advocates to appear in court and clarify issues. That's what I said. That is the crux of the matter. When the lawyers would sharpen their brains by listening to judges, the questions of judges. Because in Swaziland, we had you write when you file your appeal, there's a time in which you file submissions, and then you have 1 hour to appear before the Supreme Court to argue your case. Even I think in America also, Supreme Court of America, you have 1 hour also to appear and present your case. So I think that a hybrid of both, is it what, a mixture would be good. That lawyers, and that's how it is written in the civil procedure rules, that you when you file written submissions, the court may ask you questions, but I personally prefer that you should have an opportunity as a right to appear, not necessarily to ask permission. Once you have your requirement that you file submissions within a particular time, and then there should be sessions set aside for oral submissions. That's what I think.
Thank you so much.
How do they think about the Constitution? But I've told people that the Constitution is necessary but not sufficient. But it has to be understood. Hearings, the right to fair hearing. In some places where I've been, judgments were delivered, especially giving the final order in open court. So we could have 30 judgments delivered in one day, but you only read the final part and give judgments to the parties on the same day. But the idea where a judgment is given online, and you're not sure whether the parties have got it or whatever. I think that there's nothing wrong with fixing a case for hearing and for delivery judgment, so that the parties know that judgment has been given. The wider parties, not on the council, because justice is not for only the lawyers. That's my own view, but maybe it's conservative. I think a day should be set aside for judgment to be given, even if you read the final order. or the summary of judgment, as we used to do, summary of judgment and orders of the court. But if people will know, the parties and their friends will, and their relatives and their supporters will know that judgment has delivered even on this day by so and so in this and this is the result. Online, yeah, okay, but I don't know where we reached that stage yet. Thank you.
Thank you very much, Your Lordship. We have enjoyed all the golden nuggets that you've shared with us, and we are most surely have a beautiful day. And we are now going to move on to the next speaker, Dr. Anthony Kakoza, who will take us through commercial and intellectual property legal writing from copyrights, trademarks, and transactional precision. The hope is that at the end of this session, we will be able to learn the best practices for drafting persuasive and risk-sensitive commercial contracts, understand the role of precision in intellectual property litigation and advisory writing, explore techniques for drafting high-stakes corporate and regulatory environments, and if possible, examine some case studies for copyright and trademark and transactional disputes. Dr. Kakoza, the mic is yours.
Thank you very much, Zubeda, for inviting me and for giving me the opportunity to share some insights in this area and also outlining my terms of reference. I just wanted to point out, as you've read those key areas that my presentation rests on, learning best practices for drafting persuasive and risk-sensitive commercial contracts, understanding the role of precision in IP litigation and advisory writing. I would like to blend in the last two, which is exploring techniques for drafting in high-stakes corporate and regulatory environments, and lastly, improving clarity and effectiveness in legal documentation. So for those last two, I want to place them within the first two because they also kind of encompass techniques for drafting. So thank you. Within the time that I have, I had thought I would give some insights from an article I wrote and had published some years back, but I would still invite our listeners to be able to download that article. It can be freely downloaded from the internet. It's on publisher-author contracts, principles, issues, and challenges. It lays out the do's and the don'ts and the key things that one needs to look out for, particularly in the copyright industry. If you're an author and you're sitting down with a publisher to help have your article or your book published, what are the things that you have to give consideration to? So it's a bit of a detailed article, and I'll just pick insights into those areas. So when we talk about best practices for drafting persuasive and risk-sensitive commercial contracts, specifically in the intellectual property realm, most of these in our area of practice have been in copyright matters and trademark matters. We haven't seen so much in other areas of intellectual property. Would love to see this jurisprudence grow, but it's mainly in copyright and trademark that I would restrict my discussion to this morning. And as far as copyright is concerned, the first thing that comes to mind is you're imagining a client walking into your office and has this idea that they want to explore. They probably don't have the finances for it, but they want to go ahead and they want to see how the legal protection can come in for that idea. So having a non-disclosure agreement done is very key and important, and many people take this for granted or decide not to even think about it. They just say, okay. I mean, of course, for you, the lawyer, you have already automatically a fiduciary relationship with that client that you're not going to go out and disclose everything. But if they say they don't have the finances and you see that the idea as expressed can be exploited by a financier or an institution, advise them or even help them to draft a non-disclosure agreement or a confidentiality agreement. We may be familiar with a case some years back where some students of Makerere University, who later on started a company called Digital Solutions, were sharing their idea of what they called me to you, sharing of airtime from one phone to another. And they went to MTN, told MTN that we have this beautiful concept and this is how it's going to be played out. MTN bought into the idea and even started practicalizing it without so much as respecting any contractual obligation with those young men. So when they took the case to court, you find the case of Digital Solutions versus MTN. It wasn't in their favor because they hadn't thought about how to protect the expression of their idea and were more interested in seeing it practicalized by a big industrial player without protecting their interests. So a non-disclosure agreement is very important to be, or a confidentiality agreement, because it puts the parties into a sort of obligation to protect the interests of each of the stakeholders, especially those who are fronting in the intellectual property idea. Further on, with copyright, think about someone who has expressed his thoughts into a book and is now sitting down with a publisher. You either have an exclusive license, that this is the only publisher I'm going to work with, including for derivative works, or you can have a non-exclusive license that allows that publisher and other players to work in different facets of how your book can be exploited. So for instance, you may say, giving this publisher a license to only the print version of my book, but not for e-versions of the book which may come out at a later stage. So that is a non-exclusive license. And even within that, you would have to be key on sharing of what they call royalties. Royalties are the income that come to an intellectual property holder. Since the publisher is going to incur costs for publication and distribution, which you are giving him by virtue of that licensing arrangement, how are you going to share the proceeds from that? So you would respect that because the publisher is incurring those costs, the author is going to take a certain amount of percentages. And in the market field, it's normally 13 to 15%. This is a global position where authors normally take 13 to 15% of royalties because the publisher incurs quite a lot of costs in that area. So you have to think about the nature of work that you're allowing another party to exploit, you as a copyright holder. Is it just the literary works? Is it also to exploit any dramatic works that may come out of it? For instance, someone wrote a Harry Potter novel. It became a huge sale. But a movie came out of that novel. What if dramatic versions come out, theoretical versions of that novel also come out, or even cartoon versions? How are you going to allow further parties to have an interest in all those versions? This has to be catered for into an agreement. Then lately, we also think about issues related to revocation of copyright, and this has been included in the current Copyright and Neighboring Rights Amendment Bill. What we mean by revocation is that if I give an assignment, I'm assigning my copyrights to another party because I don't have the financial capital to exploit my copyright, I just want money now, I hand over all the rights to my book or all the rights to a manuscript for a movie, you name it, whatever type of copyright it is. The revocation principle is to the effect that at a given point in time, I can recall my interests or my rights in that copyrightable work. And this should be a lengthy period of time, say 20 or 25 years. It's there in the US Copyright Act, it's there in the South African one, and it has been introduced in the Ugandan Copyright and Amendment Bill, which is soon going to be an act. So this is allowing a person who, for instance, may have had a disadvantaged position in entering into an agreement to assign rights to his copyright work to call back those rights at a later point in time. And like I've said, probably about 25 years, because you're looking at the duration of copyright being the life of the owner plus 50 years after death. So you've allowed enough time for whoever you assigned your rights to and now recouping them through a revocation would be ideal with that. And that has to be placed within the agreement that you're signing with someone that you are signing the rights to. So you have to think about also the use of artificial intelligence. These days, every talk on anything has an involvement in artificial intelligence. As Chief Justice Emeritus was talking, I thought about judgments now that involve artificial intelligence, or even written submissions that involve artificial intelligence. The lawyer would be given time by the judge that write a submission and submit it at such and such a date. He goes back and types in a few things into ChatGPT, and ChatGPT comes up with a submission for him, which he then submits to the judge. Or even the judge, in his judgment, uses artificial intelligence to write the judgment. We've had such cases happening, and they come out as embarrassing at the end of the day, because what many people do not understand is that artificial intelligence tools such as ChatGPT rely on data. And if that data is restricted, the algorithm just searches globally anything on the internet to feed into whatever you've asked it to create. That I want submission on a case that talks about breach of contract in such and such a thing. It will look for any cases in that area to be part of your submission, and if it can't find them, it creates them. That's what they call hallucination. So it creates a case which you think actually exists when it doesn't, and then when you submit this in your court case, the judge may have to do further research to see if this case exists, and you would be embarrassed if it doesn't. We've had these situations within our Ugandan courts and in so many other places. So I was happy that Chief Justice Emeritus Odoki was talking about oral submissions. Maybe we should be going back to oral submissions to avoid people's reluctance or laziness in using artificial intelligence to write their submissions, because it's not helping anyone at all. And as far as copyright ownership is concerned, with any writing, and not just submissions, any writing that is done using artificial intelligence, the law is still vague as to where ownership lies, because we haven't come up with any concrete legislations at a global level on ownership of copyright works that are produced by artificial intelligence. Yes, the European Union came up with the Artificial Intelligence Act, I think this was last year, but it's not specific on copyright ownership. Brazil is working on a similar legislation, it's still in draft form, but the question has always been that since artificial intelligence is not human, it cannot own intellectual property, because intellectual property is creation of the mind. In Uganda, thankfully, our Copyright Act says the author has to be a person, and AI is not a person, so you can't have AI owning copyright. So I want to then go on to issues related to trademarks as far as best practices for drafting persuasive and risk-sensitive commercial contracts are concerned. Again here, the normal practice as far as trademark areas are concerned in transactional matters is licensing agreements, which are the most common. We have assignments where trademarks are being assigned from one party to another. But in the area of licensing, we see franchises here and there. And these, when someone is thinking about what to draft and how to draft them, the particular areas of concern are on the territorial area where the franchise is going to be. Who is the owner of the trademark, and in which area are you allowing the franchisee or the licensee to exercise or practice your trademark? Of course, the Trademarks Act talks about such an assignment or a license also having to be registered with the Uganda Registration Services Bureau. But do not leave out a provision over the territory, and be careful as to the duration of the license being given. So we know that with trademark, the duration starts out as 7 years after first registration. And then it's renewed for 10 years indefinitely, 10 years and on and on and on. So if I'm giving a license to use my trademark, it should be for a reasonable period that allows me to either recoup or call back that license if things go bad, or to keep renewing it if the arrangement is working out well. So duration has to be thought about in terms of the license. Then another interesting issue in terms of contractual contracts, commercial contracts, and the drafting of them is what they call FRAND terms: fair, reasonable, and non-discriminatory terms. These are terms which allow the licensee to enjoy a good contractual relationship with the licensor, not just for trademarks, but even copyright, and more so for patents, in which there's flexibility as to how the licensee can enjoy the license that has been given to him by the licensor to use and market the technology, if it's a patent, or the trademark, if it's in the area of using someone else's brand in a different locality. Why this is called fair, reasonable, and non-discriminatory is that you're supposed to, as the one giving the license, you're supposed to allow for economic development to flourish, where you've enabled another party to enjoy your intellectual property. And this stems from the TRIPS agreement. The TRIPS agreement refers to trade-related aspects of intellectual property rights agreement. It's an annexure to the World Trade Organization Agreement of 1994. So going into 1995, and Uganda being a party is obligated to follow the principles within the TRIPS agreement. So through the TRIPS agreement, they are encouraging member states that sign on to TRIPS to ensure that where different parties are allowing another party to use their intellectual property, they should not have stringent or irresponsible or very difficult terms in their licensing arrangements. So this has been reflected within our Industrial Properties Act. I believe it's section 54. So if I own a patent and I enter into a licensing agreement with someone to use my patent economically or to commercialize it, I should have fair terms in the license agreement, which is then also registered at Uganda Registration Services Bureau. And within that section 54, it is saying that if the registrar is registering this licensing agreement and sees that the terms in it are so stringent or unfair to the licensee, they can refuse to register that license agreement. So we only see this in the Industrial Property Act. We do not see it in the Trademarks Act, which also has provisions for licenses. We also do not see it in the Copyright Act, which also has provisions for licensing. But nonetheless, because it is a global position and Uganda is moving towards also recognizing FRAND terms in agreements, the people that draft them should ensure that, yes, there's a balance of interest for the licensor and the licensee, but there are no non-discriminatory or unfair terms. So I'd like to also move on to the second part of understanding the role of precision in intellectual property litigation and advisory work, which, like I said, includes the elements of exploring drafting techniques and improving clarity and effectiveness. Generally, what we know with litigation, not just intellectual property litigation, is that you have to give clarity to how you draft your pleadings. Many advocates these days are forgetting that the judge first reads your file before you approach the judge and you've been given a hearing date and you're appearing for your matter for the first time. So you need to grab that opportunity that this file is going to be read by the judge, or in my area of practice, if it's a matter going before the trademark registrar, if it's an opposition over a trademark registration, the registrar is going to first read the file. You have to ensure that the way you give your position has absolute clarity. So this, first of all, comes out in laying out your cause of action. We know that with a cause of action, you show that you have a right. That right has been breached, and the defendant or the respondent, if it's an application before the tribunal, is the one that's culpable to be positioned as the one that is breaching your right. So this has to be laid out perfectly. If it's a court case, if you have a right, show that you have a registered trademark. With copyright, we know that copyright does not work with formalities, in the sense that you do not have to register your copyright to be recognized as the copyright owner. It starts from how have you expressed it into written form. So bring proof that you expressed something into a written form, and then go on to show how the defendant came into take away your right. So that's what they call the but for principle, that I enjoy this right, but for the defendant having done X, Y, and Z, I would have continued enjoying this right. And this has to be clearly provided for in your pleadings. So how do you draft your pleadings to that effect? Like I've said, show the proof of ownership. Apart from copyright, all the other types of intellectual property rights, maybe even trade secrets, of course, do not require formality, but all the others need registration for one to be recognized as the IP holder. So proof of a certificate from Uganda Registration Services Bureau has to be part of your pleadings at the very onset. And how we draft trademark litigation matters is very important. So from my experience, what I've seen is that because I have it at the back of my mind that the judge is going to be reading this file, and I'm showing that there is, in a trademark dispute, either actual confusion or likelihood of confusion, I have to place out my client's trademark alongside the defendant's trademark in every discussion that I'm giving in building up my case in my pleadings. So for instance, if I'm talking about a client that owns the trademark Bata, we all know Bata, B-A-T-A, is for the shoe company or the leather company. And you have, let me just create a fictitious situation, a defendant who also produces leather products and has a mark. It may have been a registered mark, or maybe they're just using a brand in business called Bata, B-E-R-T-E-R. And that's the brand they're trying to position for their leather products. I would sue this person for trademark or passing off, because they're passing off theirs as ours. But on the face of it, if I'm just orally telling you this, that we own Bata and the defendant is using Bata, then that shows the oral similarity. And this has to be well presented in the pleadings to show that even if in writing out B-A-T-A, it is different from B-E-R-T-E-R, the law and the trademark allows for phonetic or oral confusion, because if I send an assistant that please go and buy me Bata shoes, and I'm meaning B-A-T-A, he may show up at a shop that has B-E-R-T-E-R and say, oh, these are the Bata shoes that he wanted. So that shows the oral similarity, and this has to be well elaborated in my pleadings. If it is something related to not a visual confusion, then I have to show both the plaintiff's trademark and the defendant's trademark and show where are they similar or where are they confusing each other. But not just to talk about this in my pleadings without showing the actual marks. So every time these two marks are coming up in my pleadings, I should give the actual mark as it exists and place it there in the pleadings, because the person reading should be able to follow my storyline and see that, but for the defendant having come up with this brand, the plaintiff would have continued enjoying it, and therefore you can clearly see that there's an element that is worth litigating. So it's important to show that visual or phonetic similarity in your pleadings. Some of these differences are structural in nature, because with trademark, you're arguing for what they call the get-up, the whole trademark as it is placed on a brand. So you have to present it as it is to bring out the existing confusion in that sense. And that's how you build up a case to say that I have a cause of action and the defendant is the one culpable for the same. So I believe, in a nutshell, I've explained the drafting techniques and the issues that require clarity and effectiveness. Thank you very much.
Sorry. Thank you very much, Dr. Kakoza, for sharing those nuggets on copyright and trademark law and how you can write airtight trademarks for your clients. Now, I believe that we as lawyers usually look at copyrights and trademarks, anything intellectual property, as matters that are for our clients. And yet, we could also be creators of copyrights. And I would like for you to speak of intellectual property, really. You have knowledge, you have acquired knowledge, expertise, experiences that you can reduce into intellectual property and maybe monetize it and also have it work for you. Push your brand, grow your practice, and basically grow as lawyers in this legal practice. Now that we have technology that gives us access to very many people in the world, how best can lawyers utilize these spaces, utilize the knowledge they have in order to grow in their practice? Thank you.
Thank you very much, Zubeda. So how best can lawyers grow in their knowledge? You talked about branding ourselves. Yes, it's very important to see how we brand ourselves as lawyers. Today's lawyer is slightly different, and I would say slightly, from just 20, 30 years ago, because technology has grown. We have social media, we have LinkedIn, we have various other social media tools. So even what we're doing now is exploring technology. We wouldn't have the same kind of space if this online technology wasn't here before us. Why I say that there's a slight growth in legal practice than it was previously, 20, 30 years ago, we didn't have websites for law firms. And I remember when law firms started having websites in the late 90s, those that were opposed to it were saying that the Advocates Act says we should not advertise, and a website is an indirect advertisement. But that has been ignored today because we do all have to have websites. And when lawyers have these websites, they position articles, they bring out opinions about cases that either they have been involved in or have not been involved in. They put out short write-ups on those that are clear and precise without lengthy 30, 40 page. Who has time to read 30 or 40 pages from a website? You just want something that is 2 or 3 pages that explains a legal issue or legal issues and how they've been resolved. And in doing that, whoever is reading gets an indirect understanding that the lawyers that have written this know very well this area of practice, and I would want to engage with them. So not just from websites, but also from social media applications, like I've said, LinkedIn. People always write opinions on those. So don't do this as a one-off. Keep regular at it. Even consider the, what do they call them, the baby boomers who are not so much into social media. So write in the New Vision, write in the Monitor articles and short excerpts of what you think about current trends. And that is part of branding for any lawyer. And it's very helpful for us in practice.
Thank you very much. I would like to ask the participants to direct questions to Dr. Kakoza. I haven't seen any so far. Mr. Muchibi has a question. Please proceed.
Thank you, Councillor Zubeda. Thank you, Senior Dr. Kakoza. Maybe you forgot to mention that is the president, UCLF. That is also very important. I've liked the presentation, and it has come at a time which is very critical. I think 2 weeks ago, that was on 12th August, I appeared before the Legal and Parliamentary Affairs Committee presenting LDC views on the Copyright and Neighboring Rights Amendment Bill 2025. As I was reading the bill, one of the issues you intimated about technology, specifically will be on AI, came to my knowledge. We are amending the law. The technology right now has surpassed the law. It has run very fast. Where we are in AI, it is unfortunate that Uganda as a country, as we speak now, there is no policy framework on AI. We don't have any legislation on AI. Some countries have already started it. Some have existing policies. I was very much a bit disappointed to see that we are amending the law. We are already in the era of AI, and infringement of copyrights is at a high rate using AI. I gave the committee a classic practical scenario existing, and my concern was that the bill does not address the growing role and impact of AI in creation and distribution of creative works. And the example I used is that, among other things subject to copyright, AI generates almost all types of copyright, of copyright protected material. For example, AI generated performances can replicate human voices, including those of deceased artists, raising complex copyright, moral rights, and ethical issues. The bill currently does not contain any safeguard for how AI tools should be regulated, how consent should be obtained, or how enforcement should work in the context of AI-generated content. The case study I gave the committee was the AI-generated remix of Masavu by Azawi, featuring the Letimoze Radio. Last year, that is 2024, an online YouTube user, neither that of the estate of the Letimoze. So the AI-generated remix on the YouTube has a link. It was uploaded to YouTube, and to this day, it continues to generate income for the uploader, despite the fact that both Moze Radio's voice and Azawi's original work were used without proper licensing or consent. Now, this incident highlights the monetary exploitation of AI-generated works in the absence of a clear legal framework, leaving original creators without recourse or compensation. We are amending the bill, and the committee, we are amending the law. There is a bill, and the committee is gathering views. How do we harness this challenge? Are we just going to pretend as if there is no problem? Is it this time to rethink the definition of a person under the Copyright and Neighboring Rights Act? How are these artists, for instance, going to protect their creations, taking into account that the upload of this remix has collected a lot of money when the owners, that is the estate of Moze Radio and Azawi herself, have no control. They can, and we can, as you said in your presentation, who owns now? That there comes in a question of who owns now this creation, because I can just get music, even if it has been a song is 5 minutes. I can use AI and make it 10. I can even make it 2. It comes out better. It sells more. So, who owns this recreation? And how does the artist benefit, and what recourse, if really is aggrieved, can he or she have? Thank you.
Thank you very much, Councillor Muchibi, for your query and the concern. By way of disclaimer, I was involved in the drafting of the bill. So yes, I encourage such views and perspectives. The bill does talk about technological protection measures. It brings out an aspect that we're drawing from the fact that Uganda recently, as recent as 2022, ratified the Beijing Treaty of 2012, which covers issues of the technological protection measures, audio-visual works in the online sense. So it's to that extent that it covers them. What I've picked out, interestingly, is you have shown that someone uploaded these AI-created works. So we know that, yes, there's an infringement, but there's someone behind it, even though this person used AI tools. So rather than say the law is vague and cannot go against the AI, it can go against the person who used the AI to create this infringement. Currently, US is in the final stages, if not it has already released a policy direction for artificial intelligence and in infringement matters. But where I use the US as an example, we all talk about ChatGPT and what can be done with ChatGPT. ChatGPT has been used to infringe so many copyrightable works of authors because, like I said, it draws from data. You just type in what you want and then it searches everywhere, gives you back a completed new product, but it does not have an ethical understanding that this is copyrighted work. So what have the authors done? They have sued OpenAI, which owns ChatGPT. Last time I checked, which was about 2-3 months ago, OpenAI was facing up to 15 lawsuits in the US alone from copyright owners. So, same case here. We know Azawi, we know the estate of the late Mose. They can go against the person that did this instead of folding back their hands and say, oh, this was done by AI, so we don't know who to sue. They do. You've said someone uploaded this material, so that's the one that they can go against. And in that sense, the law already covers for infringers and what can be done against infringers. It's in the actual Copyright and Neighboring Rights Act that we have today. So that's the position. Can I go to the second one? There was a question to talk about the LLM in intellectual property.
Yes, please.
So yes, Makerere University School of Law entered into an understanding with Uganda Registration Services Bureau as a support mechanism to come up with a master's in law focusing on intellectual property. I have to emphasize it's focusing on intellectual property, but not intellectual property rights. In this sense, anyone, not just lawyers, but any person who has any understanding of technical things or an interest in intellectual property can do this master's. It's still being finalized in drafting sense, and then it will be, of course, taken through the right channels of approval, but we hope to roll it out as soon as possible. And we invite, once it's ready, we will, of course, communicate so that people can sign up for it and do the LLM in intellectual property.
Thank you so much. I will go to the chat and I'm going to read Bitature Vicent. He asks, how can one determine who owns industrial rights of ammunition used in war?
Okay, who owns industrial rights of ammunition used in war? The first thing is, are those industrial rights? Because like I said, there is a formality process in getting industrial rights, such as patents. The story that we know of is of Nobel, who is the person behind the dynamite bomb. When he created this bomb, he got patent rights over it, and then he realized that it was going to cause a lot of havoc and destruction, and that's why he used his royalties to establish the Nobel Peace Prize. Ideally, industrial rights or patents are not given to areas which are likely to cause disruption to the public. And therefore, on that basis, you wouldn't really say that there are certain industrial rights given to ammunition that are used in war. Though, a disclaimer in that is that sometimes you may find that this tool has been created for other purposes and then ends up being used as an ammunition in war. So whoever created it and then also, of course, goes on to get a patent for it would be the owner of those rights. I don't know if that answers the question.
Thank you very much. I am interested in us addressing the question by Mr. Semfuka Robert. And he asks, but how is the presentation of Professor Kakoza related to legal writing, except for a few aspects? He mentioned about presentation of IP-related cases. in court and ChatGPT. And for me, one of the things that it goes back to my question. We do not realize that almost everything we do as lawyers is intellectual property. And that is one thing that I wanted to demystify. Right now, this presentation, during this presentation, we are creating works of the mind. And this property is the property of the organizers, ULS and MAMC. So if you are using this to make money or to basically without permission, you are infringing on the rights of others. When you write an article, that is your intellectual property. I would like Professor Kakoza to take it from here, because that point I need us to emphasize, because we usually look at intellectual property as something that is distant from what we do as lawyers. Thank you.
Thank you. I started off by talking about the kind of contractual agreements one writes and what one has to be clear on about non-disclosure agreements or confidentiality agreements. That is all legal writing. What one has to be key in thinking when you are about to either license your copyright or trademark to another party, what are you giving them? I give an example that if I've written a book and at that point it's still called a manuscript, and then I enter into an agreement with the publisher over my manuscript, I should clearly think about how far my manuscript is going to go. Is the publisher only given rights over publishing the hard copy, or am I giving him rights over the e-version property? Because there's no creativity in a person's image. But if I've written something down, then that's my copyright. Beyond that, of course, I can have all sorts of proof that that is my copyright. People may have seen me writing it, they may have signed onto it. But if I need concrete evidence that the court can rely upon, then I can go to URSP and have my copyright registered and get a certificate of registration. But other than that, I don't need a certificate to show that I own the copyright. But as you've said, even what we're doing now, if this Zoom is recorded, then the sponsors of this webinar, together with ULS, would be the ones that own the copyright, because in the recording, they have it placed into a medium or a fixed form. And someone who is watching this and has probably has used some kind of technology to also do a recording on the side, what they call bootlegging, would be doing it illegally, because the law says you have to get permission from the owners of the work before you use it or record it. So that's quite essential.
Very much. Bita Ture is very pleased with the LLM program, and he thinks it will help. He says, earlier I raised the issue of whether introducing LLM in legal practice will aid. So is it LLM in legal practice after the bar? That's interesting. Cynthia H. Musoke. Sorry? Yes. I think that is food for thought. Maybe it's something that can be considered. I personally do not believe in, I feel like she just said legal writing is an art that can be improved through practice. Rather than you going to class and have obtain an LLM in legal writing, I feel like it is something the practice should be encouraged and should be done at a larger scale maybe in order to improve our writing. Cynthia says, I think his execution was spot on. Dr. Kakoza, your execution has been commended. And sorry about, I think Bita Ture, the person who asked about raised, Professor Dr. Kakoza, would like to thank you very much for that wonderful presentation. And I would like to also commend again our partners, Utamu. They have now a School of Law, and they combine law and technology, so you can utilize their services. I'd like to commend Justice Chibita. He stood with us and made this writing masterclass. Please cover types of pleadings, clarity in drafting pleadings, the importance of judicial guidance, ethical responsibility in drafting pleadings, the emerging role of artificial intelligence in drafting pleadings, and techniques and mastering the art of pleadings. Thank you.
Thank you so much, our moderator, Councillor Zubeda, for that brief. Allow me also thank the first presenters, CJ Emeritus, Benjamin Odochi, Senior Dr. Kakoza, for all those insights you've given us. Now I want to turn to my part, and I would want to start by saying that pleadings are wide, or legal writing as a subject is quite wide. But focus here is put on court documents, specifically pleadings, because even court documents can be several, but we are trying to look at majorly pleadings. And in this case, it's more to do with the civil world. I must briefly say that before we even go into pleadings, there is a critical area that can inform whether we are litigating or not. That is the pre-action documents. Sometimes we don't begin by filing a case to court. We begin by issuing demanding notices, trying to see whether the matter can be handled without litigation. And this is where concerns have come up today in the legal fraternity. The quality of demanding notices we get today are more of Palestine-Israel bomb threats as opposed to legal documents. Someone will write you a notice, and the legal is writing to an ordinary person, but the legal jargons in that notice leave the person even more confused of what he's talking about. Or the language is almost creating another dispute instead of trying to solve that dispute. The language is so intimidative, is so unprofessional, abusive, among others. So that's where the concern has arisen to do today. Then the other also concern is when somebody presents to you a clear notice, demanding notice or notice of intention to sue, and expects you to respond courteously, to know your position. Now today, another public outcry has been the responses are also sweeping statements. And this is majorly now from the lawyers who are given instructions to respond. Somebody will just respond with one word or two words, please sue. That is a response to demand notice. And this is where the society is concerned, the public. What kind of legal writing is this? I wrote giving you allegations of my client. It's saying ABCD. I want to hear your side, because that can change my advice to him or her, whether we proceed with court action or not. Tell me what you think. Attach for me relevant documents. Actually, the practice has changed. The earlier practitioners, some of them used even to write a demanding notice and even attach you a draft plaint that this is what I intend to file should things stay as they are, so that you even get to know what nature of case is going to be brought against against you. But of course today the economy is a bit tight. Lawyers are too busy, they don't have time. It is hard for someone to go that extra mile of drafting a draft plaint to attach on a demanding notice. But the whole issue was all to really alert you. This is the case I can have against you. Please respond to me, and I see whether I can continue with this plan or not. And in most cases, once you give a proper response, answering all the queries, clarifying, and also attaching documents, any reasonable lawyer who reads and appreciates can change advice to a client. And this helps because it comes at an early stage. It helps us all, one, to reduce case backlog. There are cases filed in court, which from word go shouldn't be in court. But those cases are going to be there and stagnate the system for 10 years. All of a sudden to have it dismissed after 10 years. Then it also helps the clients to get quicker remedies in terms of if really the matter is simple, you can advise a client that you see, you are saying you are demanding a man 50 million, but he has availed the evidence, he has been paying you, the balance is only 5. This is what you are demanding and is willing to pay it. If the information is true, let us get the balance and have this closed. So your client gets a quicker remedy. Also, it helps you to know the nature of a client before you. Some of them are not very honest when they come to the lawyers. They want to give misleading facts, which you discover later in court and even feel ashamed. But at this level, if the other side gives you a clear response outlining everything as it happened, it also helps you to determine whether to continue or not. And if you are to continue, which kind of case are you going to present before court? So I wanted to just make a mention of that the pre-action stage is also very critical, and it has raised public concern on the part of lawyers that our writing today does not demonstrate professionalism, does not demonstrate training, does not demonstrate courtesy. We even write to each other, shooting one another, etc. So we need also to factor into that. Now coming to pleadings. Pleadings speak a lot. I think CJ has mentioned about it, Emeritus. Dr. Kakoza has mentioned about it, that the quality of the pleadings you present before court can easily tell court whether you have a case before it or not. Of course, maybe what can disappoint you in the future is if maybe the evidence doesn't come out or your client lacks that evidence which you seem to have also seen before filing. That is also another important aspect. So, once you prepare good pleadings, they do communicate a lot. And today, we should avoid the system of lawyers and the public defining us. If I see pleadings from Muchivi and Cheune, I know there is no case there, because I know their pleadings are very poor. Then if I see a case from Kakoza and Company, I just know that is a real legal battle. Their pleadings are very good. Why is the public defining us? It has known there are those lawyers whose pleadings are ever non-starter from word go. On peruse of them, they are non-starter. The rules allow court to peruse through a plaint, and if it determines it has no cause of action, it can dismiss it. Unfortunately, today, all those things are now in limbo because of the backlog, the case volume in courts, even signing someone sometimes before technology. It used to take a lot of time. You file a suit, only signing someone takes 3 weeks. Now, what about reading your plaint and determining etc.? It is something very now hard. But the point is, a good case is also determined from the nature of pleadings. How good are these pleadings? How are they drafted? How do they disclose everything required of pleadings? And that takes me to the nitty-gritties now. I'm not going to be so much educating lawyers on the law. I know we all know the law. Maybe the challenge would be how we apply the law. But the focus is we are guided by the Civil Procedure Act and the Civil Procedure Rules in as far as pleadings are concerned. And right from commencement and what a suit is, the Civil Procedure Act defines it under Section 2, and it talks about commencement of civil proceedings in the manner prescribed under the rules. And that takes us to the Civil Procedure Rules. Before that, we may also look at the act which gives us the modes of commencement under section 19, which takes us to the rules, and the rules give us the several modes of commencement. What is more important today is, does your case, maybe to first bring it in a simple language, do you have a triable case before court? What do I mean by triable in the civil world? Does your case disclose a cause of action? Does it bring out those elements of a cause of action? Is something very critical. Depending on the pleading you have, either you have instituted by ordinary plaint, which is under order 4, maybe you've come by way of summary procedure, which is order 36, or you are coming by originating summons, order 37, you are coming by petitions, order 38, you are coming by application procedure, notice of motion, order 52, you are coming by chamber summons, regulated by several orders. It all goes back to, is your case really a triable case? Does it have the elements of what qualifies that document to be before court? It is something very, very critical. So we are guided by the rules, order 19, on the contents of a plaint, what they should be, and also other orders like 6, which tells us what accompanies a plaint, for instance, a summary of evidence. So it is always very critical to take into consideration that any good plaint will have some general principles and particulars that have to be manifest. For instance, we have a brief statement of material facts. We have a summary of evidence, which includes lists of witnesses, the documents and authorities we are going to rely on. Those are very critical issues. And when you talk about pleadings, they apply in an adversarial system we are in. We have an adversarial system where we have a plaintiff, we have a defendant, we have a petitioner, we have a respondent, we have an applicant, we have a respondent, an appellant, a respondent, etc. So it is an adversarial system. So either party has a role to play in his or her pleadings, whether you are the one bringing an action as a plaintiff or you are defending an action as a defendant. So we have to be very critical depending on what nature of pleading we are dealing with. If it is a plaint, the law guides us what must be constituted in a plaint. But certain issues are very, very critical. One, what is the brief statement of the material facts your plaint is having? What orders are you seeking from court? What facts constitute the cause of action? What affirmatives are you giving court to buttress the cause of action? And the reliefs you are seeking from court. Those are very, very critical issues. Factoring into issues that may be presented by the opposite side, which may be statutory defenses other than the factual defense, but there are also statutory defenses that the defendant is likely to bring. So you have to mirror into that as you are drafting, such that you are not kicked out on a preliminary level. Somebody does not raise a PO on limitation and it shuts you properly and you are out of court. Why would a lawyer file a suit which is time-barred? And well aware, even you read the plaint itself, showing you the cause of action when it arose and when the suit is being instituted, and there are no exceptions to address the limitation, and you also present that to court. So it is very, very critical as we draft, we look into those defenses that certain defenses the other side is likely to raise and either cure them in our pleadings. For instance, your pleadings is premised on fraud. What are the particulars of fraud? Have they been disclosed? And also here comes in another limb where courts are also interpreting. The rules can guide on that if your suit is premised, the cause of action is fraud, please plead specifically the particulars of fraud. Later on, courts make decisions and say that even if these particulars were not specifically pleaded, but evidence was laid on fraud, and you had the benefit of responding to that evidence through examination, and that is cross-examination, the court can still allow fraud. Whereas there are decisions of Supreme Court and Court of Appeal to that effect. We don't want to be risk takers. The starting point is that can we comply with the law? The rules now guide you that please particularize by way of pleading particulars of fraud, misrepresentation, bring them out. So first explore what the law says. Later on, if you have missed out something, either inadvertently, then you can run to what the decisions of courts are saying to rescue yourself. And it is a very serious issue under Order 7, Rule 11, that once your plaint does not disclose a cause of action, you have no case before court. So we don't want to. How can really a trained lawyer advocate file a plaint without a cause of action? Or merely stating the facts constituting the cause of action are as follows, and what we read there is not a cause of action. But you are even telling the judicial officer, the cause of action is disclosed under, it is always paragraph 3 or 4, depending on the plaint, in most cases 3-4. Now, our cause of action is under 4, but when we read paragraph 4, there is no cause of action. So really, you are doing a disservice to that client. It is not something we would expect from a trained practitioner. Then WSD, you are sometimes representing a defendant on the other side. And what are you expected in this case to do also? You need to respond to each and every particulars given in the plaint, either specifically by way of giving your response or denying what the defendant has pleaded. I mean, what the plaintiff has pleaded. And in this case, we avoid issues like total denial, because the law does not accept total denials in pleadings. Your defense will be struck out. So we have to specifically respond to the plaint, and where you find that your client has a counterclaim against the plaintiff, Order 8 also rescues you to bring it at that what? At that level. And let it really also contain a cause of action, because now this is a cross action, which must disclose a cause of action against the other party. I've sometimes received WSD where there is a counterclaim, and in reading a counterclaim, there is no cause of action. But somebody is seeking certain orders against the plaintiff. So that also causes a problem. We also have a reply to the WSD. And this reply, the law does not make it mandatory, but where in your wisdom as a technical person feel that what the defendant has raised really requires response, it is very important that you file a reply to that WSD. Otherwise, the law will deem it that you are admitting what is contained thereon, if not specifically pleaded to by way of filing a reply. So it is very important that we capture those principles, and those principles are all guided by Order 6, Rule 1, 2, 3, 7, and Rule 27 of the Civil Procedure Rules. There are certain critical issues we need to be noting while drafting. While drafting, we need to ensure that our pleadings are clear, that is the emphasis on clarity, precise, that is precision, and fairness in litigation, allowing the other side to understand what exactly your case is to enable him or her respond to it. Now, clarity is the hallmark of effective pleadings. Clear pleadings must have material facts flowing in a logical order. You are giving us facts constituting a cause of action. Can you narrate how you reach that cause of action? What happened and until you think your client had to move court? So we need that logical flow to appreciate and understand. That's why when you read some plaints, you tell a client, now what is the defense? You are really on the wall. You feel that the man has a very serious case against you. And that's when you find some clients telling lawyers, no, I agree that case is okay. And I know the case, but you just file a defense, let's buy time. And that takes us to the ethical issues I'll point out later on. There are those cases which are in court for not litigation, but for buying time. Something I think we need to fight, because once we fight that, the backlog in court can even reduce by halfway. Some matters are not for decisions. Some matters in court are for buying time. And what has caused the problem is when we have few judges, or when sometimes judges are overwhelmed, or some are lazy, those cases keep piling, and now the public gets to know that, oh, court is the avenue for buying time. You can always go there and buy time. Somebody who has been threatening to arrest you, you tell him the matter is now in what? In court. He has been threatening to evict you out of the house. The matter is now in what? In court. It is in court for 10 years. That area we shall also see how we need also to address it. Then state material facts only in your pleadings. Because at the end of the day, the court is not interested in these rumors. We are only interested in those facts that lead us to contention. And the contention is what is going to help us formulate issues for determination. So let's be more focused on stating material facts while drafting our pleadings. I talked about the logical flow. I can also repeat it by saying logical organization of your pleadings. If you're drafting a plaint, we need it to have a coherent narrative, use numbers to really separate paragraphs, and how you are paragraphing, you enable us to know this is leading to the other. And each paragraph should contain a fact that really is worth attention. Brevity and directness enhance clarity. So as you draft you bring out those facts you feel are going to squeeze the defendant legally. And perhaps the defendant has no any other option other than seeking a settlement in this matter. That is what you should always be arriving at, that I must squeeze this defendant in this matter to see that the first thing to think of is settling this matter. And good lawyers are lawyers that give a client the remedy faster. The client may not be interested so much in a well-reasoned judgment. It is good for precedent, it is good for jurisprudence, but the client is interested in a remedy. So it is us who are in the academia, the Dr. Kakoza, who will be citing these cases. But the client wanted a remedy. For him, wanted his money paid. Wanted somebody to leave a house. And once you leave a house, that's the end of the story. It will be us in the academia, in the legal fraternity, saying the locus class case, but even the owner of the case no longer even remembers what happened. For him, it's not a remedy. So as a lawyer, you need to see that when you are drafting, what brings a quicker remedy to your client? And one of that is settlement, either by way of mediation. The client is going to get a quicker remedy than going into this protracted litigation, which takes a lot of time. Now, as I talked about, particulars where necessary are very important. Then language, plain language. In drafting, there are some cases, nature of cases, where legal jargons can be put. But in most cases, when we are drafting, we would really encourage use of plain and clear language. Of course, it is English, but avoiding so much legal jargons. you find somebody drafting a plaint, but it's as if writing written submissions. And you wonder what are we on? Are we on pleadings? We on submissions. Another one is drafting a plaint, but is already giving evidence within the pleadings itself. So we need to separate these things, because the law has already given us procedure and separated everything at a level. Pleadings remain pleadings. Evidence, we shall entertain it at hearing. So don't bring so much evidence in form of testimony while pleading, but you can attach documents to buttress what you are talking about in your pleadings. Then there are things you need to avoid while drafting. Vagueness. You find a paragraph. I've read some of these pleadings. You know, when you stay longer in the field, you also see a lot. Somebody serves your plaint, and a paragraph is almost a full page or half a page. You read and get lost somewhere. You fail to lose track. I mean, to have track of the pleadings. So packed, too verbose, it is something you easily get lost. So let us have really something very clear and not too detailed. Then inconsistency within your pleadings. Somebody is drafting a cause of action, but is also giving a defense to a defendant to use, or is also admitting certain things which is empowering the what? The defendant. Or you are attaching documents that are empowering that your case is weaker. We have those kind of cases in court where you find the defendant and say, I will rely on Annexure A of the plaint. I will rely on Annexure B. So the defendant is relying throughout on your documents. Then there is a problem there. There must be a problem. A defendant should be in position to bring documents to attack yours. But where you find the defendant is relying everything on yours, just know your drafting has issues. Your appreciation of the case has serious what? Issues. I've talked about overloading pleadings with so much. Then also, they shouldn't also be too skeletal in nature, too brief in a nature that when you read, you cannot also understand. We have to strike a balance, not being too skeletal in nature, and again, not being too wordy to confuse the reader to understand what you are drafting about. Then sometimes we need to read back. There are pleadings they serve you and you wonder where the lawyer read through before serving. And when you are in court, you also ask him, counsel, what does paragraph 5 speak to of the plaint? And he's also reading, he's simply lost. He also cannot also substantiate what he meant. Then immediately he's asking court, we seek leave to amend. Now, you are amending because of your poor drafting skills, but the client gave you a proper case. And this is where you find a client raising a hand in court, telling a judge, my lord, I want to speak. But the client is represented. And the judge doesn't want to allow him to say, you instructed a lawyer. He has to speak for what? For you. But the client is realizing the lawyer did not bring out the what? The case as it is supposed to what? To be. What is in the plaint is not what is in the mind of the client. So the drafting can sometimes disappoint you or even disprove you to be a good lawyer before your client. Then we need precision and conciseness in pleadings. Every word counts, right from the names, dates, figures, descriptions you are giving. You are dating sale agreement, you are referring to a certain sale agreement. The date thereon is different from what you are pleading in the plaint. These are all going to cause you problems of seeking amendments, and that is prolonging a trial, prolonging the case in court. To avoid you need to avoid some of those minor issues at the drafting level. Look at the names you are using in your pleadings. Are they the right names? Are they the ones in your document? Sometimes you are pleading something different from the document you've attached, yet you are making a person to refer to it. But when he reads the content of the document, doesn't tally with the pleading. then that is still a drafting weakness. So we need really to read and understand our documents very well. I talked about conciseness, to avoid being repetitive. You read 4 pages, but you can summarize them in 1 page. The draftsman, the lawyer now drafting, is repeating himself in more than 1 paragraph, talking about the same thing. That is not really important. We need to avoid being so repetitive when we are drafting. Then consistency, use of uniform terminology, prefer the terms used in law or contracts, but not going so much into legal jargons, as I said earlier on. Then also, when it comes specific denials, as I said, when it comes to WSD, there are denials you can specifically deny that they are not within the knowledge of your client. There are those paragraphs you need to respond to specifically by giving your version, and also avoid so much filing a WSD which is totally denying everything. That is not permissible under the law. Then, how do we become accurate and also factual while drafting? And this brings out the aspect of being truthfulness. Factual accuracy. Facts must be verified with the client. Now, this modern practice is a bit terrible. There are clients who are instructing lawyers on the phone. Gives you facts on phone. By the time you started drafting, you even don't recall the facts. So you are always on phone calling a client as you draft. If you realize that that method is not working for you, please, the best is organize a meeting. Sit one-on-one with a client, take notes, and be clear on each and everything. Or tell a client to send you a written memorandum, if he can write, in his own language understanding, which you can read and later on translate or qualify into what you want. Then also, we need to also be very, very ethical. The client will come and tell you, for sure, I'm having this case, but I know it is a weak case. But today, it is the only thing that can give me relief. Truly, I didn't pay for that man's land. I don't have the money. And the agreement was clear. If I don't pay the balance as per this date, he refunds me. And the man is willing to refund the deposit. Everything is clear as saying. And that is what our agreement says. But the man tells you, I know you people, you can go to court and get an injunction. Then we delay there 5 years as I look for what? For money to address this problem. And those nature of cases are so many today. There are very, very many in courts where people are only buying time but not addressing the problem. So try to tell this person, can't we engage this man? And maybe agree and have an addendum to our agreement the way we want it to be. So the ethical part comes in here. A lawyer also knows the truth, but the truth is not spoken in the pleadings. The pleadings are speaking something different. And such lawyers are very quick to get interlocutory orders, interim orders, temporary, sometimes even ex parte. So we need to be really truthful to ourselves. We also need to be ethical. What best advice can you give a client than wasting time going to court to really prolong matters for no reason? So we need to act with honesty. We need to act in good faith. We need to also bear into mind that these cases have already a problem to courts. And we are the ones always crying of backlog. So, and we're also contributing to this backlog. This is something we need to factor into carefully. Then also client authority is important as part of ethics. Sometimes you draft things the client never told you, but you think it will work for him. The day client is put on the stand, he's denying and say, I never told you. I've seen this in cross-examination in court. The client say, I don't know that. I've never told that to my lawyer. Then the lawyer, you are on the wall, and you are not now going to start defending yourself. So we really need to have client authority or consent on what we are doing. Also, let the client know what you have drafted before you file it. Read back to the client for confirmation. Try to simplify by, at least if the client is not well educated, translate to him or her in the language comfortable, and ensure that what you are filing in court is the position known to the client. Otherwise, we are going to have a clash in court, and subsequently, we are going to have disciplinary action, matters going to law counsel, among others. So we need really to be ethical and also engage our clients. And that takes us to the issue of professionalism while dealing with this area. We need to remain professional, knowing our lane, that we are experts, we are advocates, we don't cross to the lane of a client. That is also very dangerous. Then, when you talk about technology now, it is important, as we are talking about drafting court documents. We started with judgments. Technology has now taken over. Dr. Kakoza also talked about AI tools, ChatGPT, among others. Today, lawyers are using technology in drafting. How are we going to have use of technology to help us effectively achieve what we want? On the side of the bar, it is drafting pleadings. On the side of the bench, it is drafting decisions, whether they are rulings, judgments, etc. We need to know that we are in the era of technology, and technology will not wait for us. Whether we want or not, it will move on. So if we are to use technology, we have to be very careful. For instance, AI, which is now the modern trend. We need to know that AI is a tool. AI is an assistant. Lawyers are making AI their lawyer, as opposed to using AI as an assistant to help. The hallucinations Dr. Kakoza talked about here, we see them today even in judgments coming from courts of record, surprisingly. By the way, not in Uganda alone, but globally, judges are complaining, lawyers are complaining that they receive decisions and the citations are AI generated. The sources are wrong. Lawyers have written submissions using AI, and AI, because your search engine gave it words it wants to use, it has searched everywhere and come across those words and has given it the source as a case. And the lawyer gets excited. Oh, I've landed on an authority that speaks to my facts properly. And comfortably submits that to court. And really looking into the thing, the case is fictitious. Doesn't exist. Because AI also suffered adding those words, borrowing from one source to another. So we need to understand that AI is good, but it is merely a tool to assist us. We still remain with the discretion to confirm what AI has given us as to whether it is genuine or not. So AI is going to remain properly an assistant. And it is going to help you do work faster, but you have to verify, authenticate, and confirm before you rely on what AI has given you. Otherwise, we are going to have a situation. Recently, I got a client who wanted a land agreement. Funny enough, giving me instructions, he sent me, I've drafted something. You can look at it. This is a land sale agreement. Looking at it, I could easily tell this is what? AI. But at least it was giving me his facts, which I had to verify later on. But there are certain things that are out of context of the agreement he wanted. But they are all there, and the agreement reads using very good language. You may think really it is final, but not. When you go through, there is a lot of error that was not necessary. So this is telling us that clients are moving faster using technology. Before they come to a lawyer, they have also done their research using AI assistant to see. Now see, if a lawyer you are not careful and the client doesn't give you that draft and tells you draft for me an agreement, you use the AI. Now you are going to send him or her what he exactly has in his hands. And you will wonder whether you are now a lawyer or you are now also relying on AI. So we need to be very careful as we embrace technology. I like it, it is good, and I must say it is unavoidable. We need to really use it, but carefully, to avoid this kind of hallucinations that come up with all this kind of technology. So even in authorities in court, as we submit to court, we have to be very careful of the nature of authorities. The same applies to our members of the bench. As you write decisions, be very careful. CJMate has talked about today research assistants. These days they are called research magistrates that are attached to the judges. I know some of our lordships don't have time, so when this research magistrates draft an opinion, it is converted into the final what? Judgment, without a second eye, without authentication. And when we start reading for reporting, you get amused to see authorities relied on. They are all AI generated. They are fictitious and not genuine. So this can cause a lot of professional embarrassment. So we need to be very careful, but we must embrace technology to help us. So we can use AI as an assistant, as a tool, not as a final tool to help us. So mastering the art of drafting is something that is very pivotal to all of us. It is very important that we, as advocates, we take into consideration the following. We focus on material facts, logically organized. We be concise but complete. Double check all details of your pleadings to determine that it is accurate. Comply with procedural rules. The distinction between us and non-lawyers, that for us we have rules governing us. So you cannot completely hide away from them. Actually, you must always look at them to guide you. Uphold integrity and professionalism. Then embrace technology cautiously to enhance efficiency and also manage time given the too much workload we are having as lawyers. As I conclude, I must mention that a good lawyer can be seen from the pleadings he or she drafts. A good judge can be seen from the quality of the decision he or she has written and rendered. There is no much defining factor than those two. You will not make a better case in court if the pleadings are poor. Everything is going to rotate on your pleadings. So the starting point is to have very good pleadings. Then you can easily pursue your case to its logical conclusion. Let us not do it the other way around. Have poor pleadings, then you think we are going to have a better case in court, unless the judge or the judicial officer is also not awake. So it is always from the drafting level that will help a person know, I'm not pursuing this case, I'm going for mediation, because whatever is disclosed against me is serious and evidential. So it will help us minimize case backlog, save time in litigation, give clients quicker remedies, and also make lawyers make money in the shortest time possible without going into this long protracted trial. I thank you.
Thank you so much, Mr. Muchivi, for that wonderful presentation. it handled a lot of the concerns that lawyers and judges have in this AI-fired practice now. I would like for Dr. Kakoza to first respond to one of the questions that was not handled before we delve into the comments on Mr. Muchibi's presentation.
Thank you very much, Zubeda. So Dorothy Ochola asked, are there any jurisdictions where employees can seek ownership of their creative works, even while generated in the course of employment? So yes, that's an important question. In all the different intellectual property legislations that we have, it's particularly the Copyright and Neighboring Rights Act and the Industrial Properties Act that have specific provision on works created by employees. So when you look at the Copyright Act, Section 7, it says that in the absence of a contract, the work belongs to the employer. So if I'm working for someone, come up with something that I create, ideally, my employment contract should spell out who owns the creation. But if it does not, then the default position is that the employer owns it. When you look at the Industrial Properties Act, which covers patents, industrial designs, and utility model, there we turn to Section 19, subsection 5, which has somewhat similar wording as in Section 7 of the Copyright Act, that, again, in the absence of a contract, the employer owns the innovation or the patent or what you have created in your employment. So that's how things have been handled within our own Ugandan legislation. However, of further interest, Section 19, subsection 9 of the Industrial Property Act also says that if the employer does not go ahead to seek patent protection in what you, the employee, have invented, after 1 year, the employee has a right to go ahead and seek the patent protection and personally own that invention on his own without saying that it belongs to the employer. So that's the legislative position and our jurisprudence. The same.
Thank you so much, Dr. Kakoza. I hope, Dorothy, your question has been answered. Genevieve Akelo said, CJ Emeritus, kindly guide on verbose pleadings and copy and paste paragraphs, especially in respect to affidavits. Some affidavits look like plaints, and others have over 10-line paragraphs with hundreds of pages. The point is often lost in so many words. CJ Emeritus is no longer with us, but I also feel like Mr. Muchibi handled some of these complaints about verbose pleadings. But Mr. Muchibi, would you like to say something more?
Yes, thank you. I touched on that briefly, but I can emphasize that an affidavit, first of all, rules governing affidavit evidence do not even allow affidavits to be argumentative in nature. It's supposed to be plain. But today, affidavits have taken another form of plaints or even WSDs, depending on which side, whether it is affidavit in support or affidavit in what? In reply, which I think is very wrong. And we have so many guidances by the Supreme Court. There are so many cases of Malema Viris touching on affidavits by the Supreme Court. I think the guidance is already there, but the challenge is compliance. And this is where the problem is. Most of the rules governing pleadings are clear. They are within the law and there are decisions to support that. But where the problem is compliance as advocates. And now to dig into this problem, it goes back to the factors we've been talking about. Lawyers are never prepared. Lawyers have abandoned profession. They are now after money. Lawyers are, in most cases, not about the client's case, but how they survive. So this is what is causing some, and also unprofessionalism. But I must say, what you've raised is important, and the law supports it. And that is the position. It is something already in the know. The challenge is we should just comply.
Thank you. Dorothy says you answered her question, Dr. Kakoza. Silva Oyet says we should always remember to paginate our pleadings and all written materials. Thank you. Robert Semfuka says, Mr. Muchibi, how can I draft good pleadings without giving evidence? Take an example of affidavit evidence. I believe that a cause of action must be accompanied by evidence in form of annexures to shade a clear picture of my case to the judge. Kindly clarify.
I think I clarified that. Alluding to evidence in pleadings does not mean testifying. For instance, you are saying that, let's say it is an affidavit in reply. You are responding to averments in the affidavit in support of an application. And you want the applicant and the court to know that you have a valid sale agreement. You simply tell us that the respondent entered into this sale agreement with the applicant on this date, and proof is hereby attached, or evidence of that agreement is attached and marked A. That is the evidence we talk about in pleadings. What we are discouraging is to go into the nitty-gritties of telling us all the details of the agreement, what went wrong, how. There you are now crossing the line. But what you wanted to simply tell court that your agreement was documented and written, and you have it, you attach it. If you want specifically to bring out a clause in that agreement, you are saying according to the agreement, payment was for 2 years, not 1 year, as the plaintiff alleges. Then you just refer to the clause in your reply without telling us a story of a paragraph or a full page. That is the distinction of giving evidence and pleading by attaching documents which will constitute as evidence. So the two are different. If you are going to give the evidence at the time of pleading, you are going to have very verbose pleadings, which will make you lose even track. So we are not saying that don't refer to evidence. You can refer to it. But this is not the time to testify at the level of drafting pleadings. That is the emphasis.
Thank you very much, Mr. Muchibi. Bitature Vicent says, for the purposes of all lawyers' interest, now that the East African community encompasses both common law jurisprudence and civil law jurisprudence, won't we need a mix of both for advocates to practice in any of the member states? Why should each side continue shielding against the other?
That is who?
That is Bitature.
Mr. Bitature, I think you are taking us to cross-border legal practice. That has been a debate. Some partner states seem to embrace, others have not. Even as Uganda, we have not fully embraced. I think that can easily be addressed if the community opens up doors for cross-border legal practice and how it can be managed. There definitely must be enabling legislation to guide on the procedure and how courts can conduct matters in that way. But before we fully embrace there, you must know that in Uganda, you have rules governing your cases, how you file, how you present them to court until you finish. And you still be bound by that until we have separate legislation to the contrary.
Thank you very much. Juliet Angela says, greetings. Thank you for all the presentations. Kindly share all the presentations, especially sections that allude to AI and tech use. Thank you. Well, the presenters were speaking off the cuff, so I guess you can get the recording for this if ULS is open to sharing it. And yeah, pretty much that is all we had from our presenters. I would like to thank you all. Thank you, Justice Benjamin Odoki, CJ Emeritus, for the nuggets you shared about judgment writing. Dr. Kakoza, for the nuggets you shared about IP and commercial transactions. And Mr. Muchibi, for the nuggets you shared about pleadings and how to be how to be an AI forward lawyer without necessarily delegating your role as a lawyer to AI. I would also like to thank all of you for showing up with open minds. Professor Sempebwa could not be here with us due to other commitments, but hopefully in future we can have him. To the team at Uganda Law Society, I would like to commend you for the work well done and being open-minded to different professional development programs. And I would like to highlight the most perpendicular vice president of the ULS Society, Uganda Law Society, for the role played, the CEO, Ms. Christine Awor. Ruth, many of you contacted Ruth when you had challenges paying for the session. Thank you so much, Ruth. Doreen, thank you so much for your tireless work. Ms. Margaret Babire, thank you so much. To the team at the Uganda Muslim Arbitration and Mediation Center, Uganda, thank you. To our partners, Utamu, Professor Maria Mreva, Honorable Justice Mike Chibita, Honorable Jotham Tumwesije, and to Mr. Philip Odoki of Uganda Law Reform Commission, thank you so much. To the participants, today has been more than just about drafting clauses or polishing judgments. It's about seeing writing as a lawyer as our strongest tool. Clear words win trust, precise words win cases, and persuasive words change minds. As you live, carry this with you. The law may be complex, but our duty as lawyers is to make it simple, logical, and compelling. Keep practicing, keep writing, and above all, keep respecting the power of well-chosen words. On behalf of the team, thank you so much for being a part of this journey, and may your writing always speak louder than your titles. Bye-bye.